Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in McKinney v. Arizona. Certiorari to the Supreme Court of Arizona. Argued December 11th, 2019. Decided February 25th, 2020. An Arizona jury convicted petitioner James McKinney of 2 counts of first-degree murder. The trial judge found aggravating circumstances for both murders, weighed the aggravating and mitigating circumstances, and sentenced McKinney to death. Nearly 20 years later, the Ninth Circuit held, on habeas review, that the Arizona courts violated Eddings v. Oklahoma by failing to properly consider as relevant mitigating evidence of McKinney's post-traumatic stress disorder. McKinney's case then returned to the Arizona Supreme Court. McKinney argued that he was entitled to a jury resentencing, but the Arizona Supreme Court itself reweighed the aggravating and mitigating circumstances as permitted by Clemons v. Mississippi and upheld both death sentences. Supreme Court held, the decision below is affirmed. Justice Kavanaugh delivered the opinion of the court. A Clemons reweighing is a permissible remedy for an Eddings error, and when an Eddings error is found on collateral review, a state appellate court may conduct a Clemons reweighing on collateral review. McKinney's argument that a jury must resentence him does not square with Clemons, where the court held that a reweighing of the aggravating and mitigating evidence may be conducted by an appellate court. Because Clemons involved an improperly considered aggravating circumstance, McKinney maintains that it is in apposite here, where the case involves an improperly ignored mitigating circumstance. Clemons, however, did not depend on any unique effect of aggravators as distinct from mitigators. For purposes of appellate reweighing, there is no meaningful difference between subtracting an aggravator from one side of the scale and adding a mitigator to the other side. McKinney also argues that Clemons is no longer good law in the wake of Ring v. Arizona and Hurst v. Florida, where the court held that a jury must find the aggravating circumstance that makes the defendant death eligible. But that does not mean that a jury is constitutionally required to weigh the aggravating and mitigating circumstances or to make the ultimate sentencing decision within the relevant sentencing range. See Apprendi v. New Jersey. McKinney notes that the Arizona trial court, not the jury, made the initial aggravating circumstance finding that made him eligible for the death penalty. But McKinney's case became final on direct review long before Ring and Hurst, which do not apply retroactively on collateral review. See Scheriro v. Summerlin. In the Arizona Supreme Court's 2018 decision, reweighing the aggravators and mitigators did not constitute a reopening of direct review. The decision below is affirmed. Justice Kavanaugh delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, and Gorsuch joined. Justice Ginsburg filed a dissenting opinion, in which Justices Breyer, Sotomayor, and Kagan joined. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80, or on Twitter at Court Syllabus.